get ready for the dictation on the count of 3, 2, 1, start. Respondent full sync after his acquittal moves an application before the authorities for his reinstatement. Since the authorities did not respond favorably, he filed a writ petition in the year 1998 before a learned single judge of Rajasthan High Court. The challenge of his dismissal from service, though, was made only after his acquittal in the criminal case, yet the challenge was on various other grounds as well, such as the order of termination not being passed by the appointing authority, non-supply of inquiry report, not being allowed to cross-examine the witness, etc. All these grounds did not find favor with the learned single judge except for the ground raised by the respondent that now, since he has faced a criminal trial on the same set of charges where he was ultimately acquitted by the Sessions Court, his dismissal order is liable to be quashed and he should be reinstated in service. The learned single judge allowed his writ petition and his final dismissal order was quashed and orders for his reinstatement were made with 50% back wages. The state of Rajasthan filed an appeal against this order before Division Bench of the High Court, which was dismissed. The state is now before this court against the order of reinstatement passed by the Rajasthan High Court. We must reiterate that the High Court of Rajasthan, both in the writ petition and special appeal, had allowed the case of respondent Phul Singh only on the ground that now, since he has been acquitted by a criminal court on the same set of facts and charges on which he had faced a departmental proceeding, the orders passed in departmental proceedings are liable to be quashed and he must be reinstated in service. As we have already referred above, none of the other arguments raised on behalf of the private respondent challenging procedural anomalies in the departmental proceedings, violation of principles of natural justice and fair play, or lack of jurisdiction of the authority had found favor with either the learned single judge or the division bench. The case of the state, who is the appellant before this court, is that the respondent was a member of a disciplined force. There were extremely serious charges against the respondent in the departmental proceedings. He was charged of threatening and extorting money from a member of public roaming in a public place under the influence of liquor and then using a firearm and causing injuries, which were all very serious charges. Respondent was given full opportunity to defend his case in the departmental proceedings. He was given the opportunity to cross-examine the prosecution witnesses and, in fact, he also presented 9 defense witnesses who were examined in the departmental proceedings. The disciplinary authority concluded that the delinquent constable had committed an act of gross indiscipline and negligence as well as dereliction of duties and of misbehavior and misconduct, and all this had blackened the image of Rajasthan police in public. Under the circumstances, the delinquent officer cannot be retained in police service and was thus dismissed from service with immediate effect. The state would also argue that the acquittal by the criminal court is of no consequence as far as departmental proceedings are concerned. The question before this court is therefore only to see whether the respondent can be reinstated in service for the reason that now on the same set of charges he has been acquitted by a criminal court. There should be no doubt in law on this subject. Departmental proceeding is different from a criminal proceeding. The fundamental difference between the two is that whereas in a departmental proceeding, a delinquent employee can be held guilty on the basis of preponderance of probabilities, in a criminal court, the prosecution has to prove its case beyond reasonable doubt. In short, the difference between the two proceedings would lie in the nature of evidence and the degree of its scrutiny. The two forums therefore run at different levels. For this reason, this court has consistently held that merely because a person has been acquitted in a criminal trial, he cannot be ipso facto reinstated in service. Be that as it may, a delinquent employee, after his dismissal from service, nevertheless seeks reinstatement when he is acquitted by a criminal court on the same set of charges and facts. A very heavy reliance is then placed on a decision of this court given in Captain M. Paul Anthony versus Bharat Gold Mines Limited. Reliance was placed on this decision by the present respondent as well before the learned single judge as well as before the division bench of Rajasthan High Court. Both the courts have relied on this judgment while giving their decision in favor of the respondent. In Captain M. Paul Anthony, this court had indeed held that as the petitioner before them had been acquitted on the same set of charges by a criminal court, he should be reinstated in service.